I'm here to talk to you about the provincial perspective and the Ontario experience. And as Kathy pointed out to you earlier today, charities law in Canada constitutionally is actually with the provinces. So for those who really care about actual legal principles, the Canadian Constitution actually as a head has charities law with a provincial responsibility. We had a great presentation yesterday at lunch as well, and so I'm going to steal from John Kamick's presentation, just ask, how many people here in the audience were actually aware that there was a provincial presence in the oversight of charitable property in Ontario? Just show your hands. That's pretty good. I am going to resist the temptation to actually call out numbers to see how you feel about our office, because I don't think my ego could take the response I might get from that. But in fact, we've had charities legislation in Ontario since 1915. And in 1919, when the Office of the Public Trustee was created, and it's now called the Public Guardian and Trustee, the responsibilities for charities law actually was given to the Public Trustee to carry out. Many people are very puzzled and surprised by the fact that the oversight of charitable property in Ontario rests with the Office of the Public Guardian and Trustee. Our major function at the Office of the Public Guardian and Trustee is actually the management of finances for incapable adults. And as our law is rooted in English law, I think you can understand the reason why it was given to us in 1919 is because its root in English law is on the parents' patriot jurisdiction of the Crown. And part of the parents' patriot responsibility that the Crown had was looking after the vulnerable society, the mentally incapable, but also charitable property law. So that's, although I wasn't around at the time, so I wasn't aware of the actual reason for the decision, that's probably one of the reasons why it was given to our office to look after. And the main piece of legislation that we work under is the Charities Accounting Act. And for those who are involved in the legal aspects of charities law and been involved with our office, they may understand some of the reasons why we do things and what we do when you look at the fact that our legislation was around since 1915. So we're dealing with a very old piece of legislation. I can also advise you, though, that it is a lot smaller than the Income Tax Act. What I will look at today is I will discuss our mandate. I will compare our role to the role of the CRA's Charity Directorate. I will discuss how we carry out our mandate. And then I have a few suggestions for you should you hear from our office in case your organization should come to our attention. And if there is time, I will review some recent changes to legislation in Ontario. So, the mandate of our office. So we play a role in helping to protect charitable assets in Ontario. We do this through three major ways. Reviewing Ontario applications for incorporations of charitable organizations and corporate change documents. Protecting charitable property in court proceedings. And the one that often gets a lot of attention for either actions or inactions, as some people may feel, acting on complaints regarding misapplication of charitable property or breaches of fiduciary duties of directors and trustees. It's important when you look at our mandate on how we carry out our mandate that the Office of the Public Guardian and Trustee does not represent the public. So we carry out enforcement on behalf of the public's interest in the proper use of charitable property. We do not represent individuals. We do not represent charitable organizations. And we also do not represent trustees or executors or other individuals who are responsible for administering charitable property. We are involved on behalf of the public. Charitable property is for the benefit of the public, and there needs to be some way of enforcing those obligations. That duty rests originally through common law with the AG, and through our office we carry out that responsibility. But there is a difference. We, in fact, truly are not a regulator. We do not create the rules on which charities operate. We enforce the trustee and fiduciary obligations that come with charitable property. We do not maintain a registration system. If you want to be a registered charity in Canada with the benefits under the Income Tax Act, you have to be registered charity under the Income Tax Act and apply for that. In Ontario, you are a charity if in fact under law you meet the requirements of being a charity. There have been organizations that when we come will say, look, hold it, we're not a charity, you have no authority over us. The issue is not whether or not you think you're a charity or a registered charity under Federal Income Tax Act, but in fact whether or not your objects are charitable and your purposes are charitable. If they are, then we have jurisdiction over your operations. Our role has actually been defined by the court as an invigilator, but more of a watchdog. Our power, the true power in Ontario in dealing with provincial jurisdictions lies with the court. It's the court that has the power to enforce the obligations. We, of course, are the organization that takes you to court to get the court to impose those responsibilities. This is often a question we get in Ontario, a question of what charitable property does the PGT have authority over? As many of you may be aware, you can be a registered charity or you can be incorporated as a charity. You can register in Ontario either using federal legislation or provincial legislation. The fact that you're incorporated under non-Ontario legislation doesn't affect whether or not we have jurisdiction. We have jurisdiction over any organization that's managing charitable property in Ontario. We also have organizations that will come into Ontario for fundraising purposes. They're not really carrying out their charitable work here. They don't have any other presence other than fundraising in Ontario. We had a case a few years ago where we took an organization from the Maritimes to court for their fundraising activities, and their first line of defense was to say, look, we're not an Ontario charity. We're a registered charity, but we're in the Maritimes. All we're doing is fundraising, and the court upheld our jurisdiction with respect to their fundraising activities in Ontario. They were accountable to us how they carried out those activities in Ontario. And the reason we were involved with that organization is the bulk, if not all of their fundraising, was done in Ontario. I guess you could also say the bulk of any of their charitable activities were done in Ontario because they actually didn't do any charitable activities. They simply fundraised and managed to use all of those funds for their own expenses. We also have responsibility for other organizations other than charities that can solicit funds for charitable purposes or can hold charitable funds. And these include for-profit organizations. We're all familiar, and I always use the example of Tim Hortons because I come from Oakville, and Tim Hortons' head office is in Oakville, but they have an annual camp day where a percentage of the sales of coffee, cups or whatever they're selling or profits that day will be donated to their charitable foundation. If there was concern that they were in fact raising funds, stating it's raised for charitable purposes, but not making those payments for charitable purposes, we can inquire information from them as to what activities they've done and if they've been carrying out the charitable purposes. There are two major exceptions with the type of property that we get involved with in Ontario. One is hospitals, and that's because of a case which determined that hospitals in Ontario are very heavily regulated by another provincial organization, the Ministry of Health, although we still have authority and jurisdiction over any trust property that hospitals may hold, including hospital foundations. They are not excluded. And the other one is gaming. Any gaming activities is not regulated by our office. The Ontario Lottery Commission is responsible for overseeing gaming. The Charities Directorate. As you all know, the Charities Directorate is the federal role in administration of charitable property, which comes under the Income Tax Act. When you're a registered charity under the Income Tax Act, you don't have to pay tax on your income. And the big plus, which is why everyone wants to be a registered charity, is you're able to provide donors with a tax receipt for any donations that you receive, and that receipt may allow taxpayers credit on their Income Tax Act. So up on the screen now, I have a comparison between our office and the CRA. CRA, if you look on the far side, focuses on tax law and tax principles to prevent abuse of the charitable donation tax credit system. They're also involved with the interesting issues around disbursement quota And receipting issues is a federal issue because it's use of the Income Tax Act. Our office, on the other hand, monitors compliance with laws re the proper use of charitable assets, and to take steps, we can take steps to ensure that trustees carry out their fiduciary duties. Our focus is trust law principles. CRA's focus is on Income Tax Act. When I look at this from our probably grade 7 or grade 8 mathematics Venn diagrams. So you have a Venn diagram, you have two circles. So you have one circle, which is the CRA's responsibility in the charitable sector. You have another circle, which is the provincial responsibility. And what you have is you have a section in the middle where those two overlap. So we often have a lot of similar interests in situations that are taking place, but we're coming to that interest from two different legal principles, the Income Tax Act and trust law principles. But we still can occupy that same area in between. There are aspects of charities law that we're involved in that CRA is not involved in, and there are aspects that CRA is involved in charities law, such as the disbursement quota and receipting, that we are not involved in. So that sort of explains the Canadian and Ontario perception and reality of charities law. CRA has an annual requirement for filing the T3010, and I think everyone here is from Ontario or Canada is aware of the T3010 and those requirements to be filed. And we had a good presentation from Kathy at lunchtime about how to complete it and the importance of the T3010. We do not have any annual filing requirements, but we do have initial reporting requirements and requirements to give us information if there's any changes to your information. Power and authority, and this is the big difference when you get into this. Because CRA is, in my mind, more of a regulator, has a registration system, they can grant you the status of a registered charity. They can also revoke your status as a registered charity. So that's the big tool of enforcement that CRA has. Recently, a few years ago, there were some amendments to the legislation which allowed for other forms of enforcement, including administrative fines, penalties, temporary loss of receipting. So those are important additional sanctions and penalties that can be imposed, which I think was a great step to do as opposed to the huge hammer of you're either in or you're out. So this is, I think, was a huge improvement. Our office, we don't grant you charitable status, so we can't revoke your charitable status, so we can't stop you from being a charitable organization. If there is difficulties and if we need to take action, again, as I said, the courts are the ones with the power. So what we do is we take you to court, and the court can impose penalties or sanctions, and it's set out in the Charities Accounting Act, the power of the courts and what kind of orders courts can make. But this is another big difference which comes out of the root of our authority as opposed to the root of CRA's authority from the income tax and administrative penalties. The court can make orders against directors and trustees, the fiduciaries, because it's a trust obligation. So those who are running the charitable organizations can be required to pay back any money which had been inappropriately spent. So if you have fundraising abuses where there's been a lot of fundraising and improper benefit to directors or trustees, courts have made orders requiring them to pay those funds back. Under the Charities Accounting Act, the court also has the authority to impose fines and terms of imprisonment. I am not aware of any terms of imprisonment ever being ordered by the court, but the court has ordered fines against directors who have breached their trust obligations and have been fined under the Charities Accounting Act. Just to give you a little bit of an idea, I think everyone is aware of the 85,000 figure of registered charities in Canada. In Ontario, there are over 30,000 registered charities. Over 35% of the registered charities in Canada are located in Ontario. And those are ones that list themselves as being in Ontario. In addition to that 35%, we have all of those other charitable organizations which may operate in Ontario or fundraise in Ontario. For certain areas, Ontario is an attractive, or at least it used to be, I'm not sure if it still is now, a venue for fundraising. And just to give you an idea of sort of the makeup of charities, and these are from registered charities, 43% of the charities in Ontario are religious organizations. 16% are educational organizations, and 12% are welfare organizations. And I can tell you, dealing with complaints from charities, our experience is very similar to the UK experience. A lot of the complaints come from religious organizations, or about religious organizations. But as I indicated earlier, in addition to those 30,000 plus registered charities, we also have authority over trusts, over for-profits that hold charitable property, or anyone else holds charitable property. So it's not just registered charities that we have authority over. And there are a lot of trusts held by estate trustees. A lot of bequests are left in wills, and not as much anymore, because most of them are now being given to named charitable organizations, but there were a lot of bequests that were named in wills. I want my trustees to hold the residue of my estate and to pay it on behalf of scholarships or to help the poor or whatever in different areas. There are a lot of trusts in Ontario for those kind of purposes. I won't go into any detail, but contained in the material, and I believe you'll be able to get it on the website, is just the information of the initial reporting requirements that we have. And this is at the time your organization is created, be it by a corporation or a trust. And just sort of the information that you need to give to us. And the ongoing is only if there's any change in information. At one time, probably about 12 to 15 years ago, we used to require annual filings of financial statements with our office. We discontinued that requirement because we did not have the resources to review those financial statements. So I was of the belief that if we do not have the time to look at it or review it, we don't want that material to come forward. But when I go into our powers with respect to looking into charitable activities, we have the right to require that information to be given to us, but we don't have an automatic requirement. We don't have an automatic requirement for annual filing, and we have no set form. Can be letter, can be a copy of your information return to the corporate department that you're sending it to. Some organizations even send us their T3010, but they are not required to, so just the information that they send in to us. In corporations, I'm just going to very quickly discuss our role in corporations. We do not actually have responsibility for the incorporations of corporations in Ontario. We do, however, review articles of incorporations for charitable organizations to ensure that their objects are charitable. In Ontario, we have a two-stream process for incorporation. The first stream, which is the one that the majority of incorporations go under, is when you use standard objects. And we have developed a number of standard objects, which we started since about 1999. And those standard objects have been approved by the Charities Directorate. So if you use the standard objects, you don't even send the documents to our office, you go directly to the Ministry of Government Services. It used to be called Companies Branch, now it's verification, and this, I don't know, it's a very bureaucratic title and I can't even remember what it's called anymore. But Companies Branch is much easier and I know what it is. And you just deal with them and you can be incorporated. This is just an example of, although two separate levels of government, there is a lot of cooperation and involvement between the provincial government and the Federal Charities Directorate in the way we carry out our duties, as much as we are able to under the constraints we have in law. And there's a lot of privacy concerns that we have with what we can share, but we do try to work together and cooperate. And I think this was one of the major changes when we first incorporated, because you knew if you use a standard object that your objects were going to be taken as charitable by the Charities Directorate as well as our office. You still had to meet the other requirements for the Charities Directorate. Your activity statement still had to at least match what you said your objects, you were going to do in your objects. But this was a big improvement, and at that time helped to improve the registration process even at the Charities Directorate. The Charities Directorate have actually adopted their own, what they call model objects, which are very similar to our standard objects. And until that time that they had adopted it, they actually used to have a link on their website to our website to assist, and as I understood at that point, it was to assist a lot of organizations outside of Ontario who really were uncertain of what is a charitable object? What do you have to say to be charitable? A lot of organizations are created by people who do not have professional advisors. They're a group of people who want to do good work and they want to get created, and they really do not understand all these legal requirements to put down in writing exactly what you're going to do and to ensure that all your objects are charitable. So this was a useful tool to help them focus on what work they wanted to do and to put it in legal terms so that it was charitable, so that they can meet the requirements to become incorporated. If you want to change those documents, like anything else, it's the articles of incorporation are like your birth certificate and your constitution. That's what creates the document. It sets out what the powers you have and what you can do. And as time goes along, you may need to change it. Your name is in there, you may change your name. In Ontario, if you want to make those changes, it's called a supplementary letters patent. And we would review those. Sometimes you have two different charitable organizations that decide they're doing very similar type of work. It doesn't make sense to both be trying to do that work, so they want to amalgamate. So you do letters of amalgamation. So these kind of change documents are reviewed by our office, again from the perspective to ensure that the objects will remain charitable, and also to look at what property each may have and what you're going to use that property for in the new organization. When you're looking at corporations, over the next couple of years, you're going to see a lot of changes dealing with corporate statutes. Industry Canada has passed new legislation dealing with not-for-profit corporations. It's a great title, not-for-profit and others, but it includes not-for-profit organizations, which has a different type of process and changes. Ontario is in the process of drafting new corporate statutes. And I anticipate that it will get rid of the sort of old letters patent, the old sort of the granting from the Crown of the authority to be a corporation, and moving more to an articles of incorporation like a business corporation, which is more of an incorporation by right as opposed to the government's granting of your authority to be a corporation. So there will be a lot of changes. Hopefully, most of them will be positive changes for the charitable sector. Litigation. We have a lot of involvement with litigation. My office is required to be served in any court proceeding involving charitable property. This is a responsibility that's established under Section 5(4) of the Charities Accounting Act. And for those areas that are not covered by the Charities Accounting Act because of the sort of archaic wording used in that act, there's a case, Re Baker, which requires that anything which would have been the AG's responsibility dealing with charitable property comes to the public guardian and trustee and not to the Attorney General's office directly. To give you an example of the types of litigation that we're involved in, these involve passing of accounts. Again, I mentioned there were a lot of bequests that were left in wills to charitable purposes. And a passive account is a court financial audit, and it's the means by which the estate trustees are able to get paid, and it's an approval of their actions while they're handling someone else's property. Will challenges, interpretation of wills, and dependent relief applications. Again, there are a lot of bequests that are left to charitable purposes. Many of those bequests, the deceased leaves behind family members. Often these family members do not see eye to eye with the dearly departed and their charitable intentions. So they may challenge the will, saying there was no ability to, they were incapable or undue influence. And so what you want to do in those situations is challenge the will. If the will is defeated and there's no other previous will, then we go under an intestacy, and under the rules of intestacy, family members will get the estate. Interpretations as to whether or not it truly is a bequest to that charitable purpose or organization, And another way of challenging wills that we see a lot of is dependence relief. So the principle that if you leave a bequest to someone other than your dependents, your spouse, your children, other people who may be dependent on you, you can challenge the will, not because you claim the person didn't have the ability to make the will or wasn't capable, but because they didn't take care of their dependents. And the dependents should be entitled to receive funds first before outsiders or charities receive those funds. So a lot of what we're involved is in general estate litigation. This is distinct from other areas of litigation, which I'll get into, dealing with complaints about charities, which really deal with concerns about the operations of charitable organizations and charitable trusts. But when we're involved in this type of litigation, it's important. We do not act for a named charity. So I often get small charitable organizations that say, oh, we were served and you were served. You're the expert. You've got lawyers who understand charities law. We'll just leave it in your hands. You go to court. You take care of it for us. Sorry, we're not there. We're not the lawyers for the charities. We're just overseeing all the charitable interests that the public may have in it. So the first thing we look at if we get served with a charitable litigation is whether or not we'll even become involved. And generally, if there are named charitable organizations or those who are able to protect the interest and actually under fiduciary responsibilities have an obligation to protect their interest in the estate, we will not become involved. We do sometimes become involved, though, if there's a conflict of interest. You'll see that in situations often involving private foundations, family trusts, where the estate trustees and the directors of the foundations are one and the same. So they're wearing two separate hats, so they're not able to act on both sides of it. So we may step in those situations to protect the charitable interest. And we do sometimes become involved if there is a legal principle that's involved in that case that might have an impact on charities law in general. This is the one aspect that a lot of people are interested in and what we hear a lot of, our complaint process. The Charities Accounting Act actually provides for two mechanisms to raise complaints to the court. Section 6 dealing with one person with a complaint, Section 10 with two. And in both sections, the court has the authority to request the Office of the Public Guardian and Trustee to undertake an investigation on the case and to look at it. Primarily, though, complaints about charities do not come to us through court proceedings, but come to us directly by individuals who are complaining about the operation of the organization. We look at compliance with charities law and the preservation of the charitable benefit. And I think the thing that I found very interesting from the presentations from the UK and from the charities director today is the common themes in all of our decision-making processes when we're involved in these kind of situations. And that is an emphasis on education. We look at corrective rather than punitive. Our role is not to punish. Our role is to have organizations take steps to correct their mistakes and to take steps to prevent future errors and violations in the future. What can we look into? Again, we're not the regulator of charities. Our interest is in charitable property and the use of charitable property. So our interest is to ensure that charitable property is being used for the purposes for which it was intended. If you give a charity for a certain purpose, that property should be used for that purpose. And to ensure that those who are responsible for the administration of charitable property haven't abused their fiduciary duties. When I use property, I always have to add this because sometimes people think it means only real property, but the charitable property is all property. That includes bank accounts, investments, not just real property or chattels. So what do we do if we're involved in investigation is where we may end up with, but an inquiry is usually how we first look at it first. We actually request information from the charity. We have the right under our legislation to require anyone handling charitable property to provide us with information as to how they're carrying out their charitable purposes. This does not give us the authority to come to your property and do an audit on the property. This is probably what I think the charities director would call a desk audit. You send the information into our office, we look at the information that you've sent to us. But we don't just ask you to give the records, we'll ask you all kinds of questions and require responses to that information. When that information comes in, we review it to determine if there is any problem. I can tell you, and I think this is probably consistent with anyone who has an enforcement role dealing with charitable property, very few of the issues I come across are what I call malfeasance or deliberate actions. Most of them are innocent actions where the individuals handling charitable property are just not aware of their obligation. And so they make mistakes, they do work that they're not authorized to do, they may make payments that they're not authorized to make, but they didn't do it through any criminal intentions. Unfortunately, there are a small group that do it to try and make their own money and abuse the system, but that's a small group that's out there. So we try to get the information from them, to look at it, to see what is it. The fact that we're asking for information doesn't mean we've made a determination, in fact, that there is a problem that needs to be done, but there obviously is some issues have been raised that we need to have clarification on. So we may request further information or clarification from those who are involved with the organization. If, however, we don't receive the information we want, or if the information causes us serious concerns, then we will take that case to court. And again, because we're dealing with an old statute, the method that we take it to court is actually a passing of accounts. The charity is actually passing its accounts to the court and justifying its transactions and how it's handled the charitable property. I've just given a few information here about avoiding complaints. I think I will just touch this very briefly because I think these tips are very consistent with a lot of the information you received in different sections in different ways. The big one, and the one that often causes a lot of problems for those, know your governing documents. It's amazing how many directors and those responsible for charitable properties really do not know legally what they're able to do. Often these organizations were created many years before those people sitting on the board now were involved with the organization. The work that that organization has been doing transforms over the years. It may well be charitable work, but a charitable organization can only do the works authorized by its objects. You are not able to do all charitable work, only what's in your objects. So you're offside if you're doing work you're not authorized to do. And if you don't know what work you can do, how do you know if you're in compliance with your requirements? So you need to know where that is. So if you're on a board or if you're asked to a board, you want to see those documents. You want to see the letters patent, whatever it is, the Constitution, the bylaws, the things that set up what it is. The original letter from CRA, which registered you and set out what your purposes are and your activity statements. You want to find those documents and read it. And if you can't find it, then you want someone to take steps to locate those documents and put them in a safe place where it can be found again so that you can follow through with it. Because we're very interested in special and trust principles, different than CRA, which wouldn't have the same concern, we have a real interest in restricted or special purpose trust. Now, the property held by a charitable corporation is not trust property per se, but many corporations actually receive trust property. Anytime you get a bequest, and I believe there was a presentation earlier about how to deal with gifts and the terms attached to gifts and whether you should even accept that gift depending on the conditions or terms attached to it. But if you have a gift that's given to you which have terms or conditions attached to it, you have to comply with those terms and conditions. So if your gift is given to maintain the stained glass windows or the organ or to provide a scholarship for people from Halton who want to do nursing at Conestoga College, you have to comply with those conditions. You cannot down the road say, well, you know what, I can't find anyone in that area who wants to take that course, but we need a new staircase or we need to put an elevator into our organization. So we've got all this money in this fund that we haven't been able to use, so we're just going to use that for that purpose. You are not allowed to do that. That is a breach of trust law. But to know that you're met with your special purpose trust funds, you need to know what conditions are attached to those gifts. And so that usually comes at the time you receive the gift, and often it has been misplaced. And I was at a meeting not too long ago. It's in the shoebox, and somehow that shoebox has been missing, and so you have to find it. So you need to make sure. But there's all those tips you have of keeping your records, knowing your records, following your history, and keeping track. But the other thing that you need to know is, what are your fiduciary duties? And this slide lists out your main fiduciary duties: to act reasonably and prudent, to keep proper accounts, to not put your own personal interest in conflict with that of the charitable organization. In Ontario, and I think all of Canada, that means if you're a director of a charitable organization, you cannot be paid to be a director. We also say you cannot be paid to do other work for that charity. If you're a lawyer and you're doing work for the charity, you cannot be paid unless the court has authorized that payment. That's an area that always causes a little confrontation sometimes with different organizations and lawyers. But you have to protect the property that's under your care. If you're a director or trustee, you have to be actively involved in the decisions. You are responsible for those decisions that are being made. You can't delegate it down to staff. Staff are important. Staff do a lot of good work, but the directors and trustees are ultimately responsible, and they need to provide the general policy and directions of how you carry out your work. We have more information on our website. So I won't go into all of the avoiding complaints, because those tips have sort of been covered. But I would like to just quickly discuss what to do if you do have the unfortunate situation of having our office send you a letter, because that's how it is. We don't show up at your door, we'll send you a letter. And I think the main thing I want to say to you is, do not ignore the letter. You know what? You're entitled to get professional advice. You can go to lawyers or accountants, but you're going to have to answer us eventually, and sooner better than later. So it's important to keep us advised of what you're doing. So if you're not able to meet the deadline that's in the letter, say, look, we're gathering that information. We have a meeting with our lawyer. We have a meeting with our accountant. We hope to have this information available for you at a certain date. That's great. Keep us advised. But you can't use that to do it. And I think that the main one is number 4. You have to remember, I have to decide whether or not I want to really get involved in this investigation or go to court. So you're dealing with individuals who have to make those decisions. I get a letter which sets out some concerns in it that we think need to be investigated and looked into to see if there is any problem. What I get back is going to be determinative of what we do next. So if you're silent, you're vague, defensive, inconsistent information, then my antenna starts to twitch a little and say, well, I wonder what's going on here. Maybe there's something to this. Because we don't accept that there are problems right away. We just want to look into it. So it's important that you provide an organized, comprehensive response and provide the context. Give us the information. Often there are a lot of good reasons for why things have happened and what's going on. Remember, we're looking at it from an educative process. We don't want to take you to court. We're not interested in punishment, but except for those few small cases where it's justified. But we just want to make sure there's no problems. So, give those responses. I can tell you, filing T3010s, and I'm glad to hear that the number of revocations for failing to file T3010s, the numbers are decreasing. But we look at T3010s. We're not the federal government, but we look at T3010s. It's our first thing we look at when we look at it to see what kind of information is there. We also look at it when we get responses coming back in the financial records. Do the information on the T3010 equal what we're getting on the financial statements and the information we're receiving from the charity? So those T3010s are important not only for your federal obligations And not only for donors and others to see what you're going on and for your transparency, but if there is a problem, we also look at that to see if there's any indications of further concerns that we need to look at. And we recognize that mistakes happen. And if mistakes happen, tell us what you've done. Don't try to hide it. Don't try to worry about it. Often I find something's happened and someone's complained about it, but by the time we go into it, the board has already taken steps. They've already put procedures in place to cover situations. That's often all we're looking for. And so that's great. So if you tell us that, that's a good way to do it. And that's what we're looking for. We're looking for those who take their fiduciary responsibilities seriously. And that includes taking corrective actions when there's problems. So while these suggestions may not prevent someone complaining, because people complain for all kinds of different reasons, and do not think it's only because they have the best interest of the charity at mind when they make a complaint, but that doesn't reason. But these at least can help you to avoid it. So I'll just put up our contact information, and Mark has already put into it. But I just wanted to very briefly talk about some recent legislation and changes in Ontario. The Good Government Bill, which is Bill 212, received royal assent on December 15th, 2009. And for those who are not from Ontario, many times you go to a presentation and CRA has a lot of stuff on their information, say, you can do certain things, except in Ontario, you need to check what the Ontario law says. And those two major areas that caused a lot of differences between what happens in Ontario, provincially, and other provinces, dealt with for-profit activities by charitable organizations and owning shares in businesses, and the use of real estate. Before the Good Government Bill was passed, charitable organizations, save and except for religious organizations, were not able to hold land other than land they were actually using for their charitable purposes. So you weren't able to use land as an investment purpose. You had to have a plan on how you were going to use your land and what you're going to use land for. We have had for some time in Ontario the Trustee Act, which provides for a prudent investment standard of how you deal with your investments and a plan and setting it up for that basis. So with the Good Government Bill, we actually removed the restriction on the use of land. So charities in Ontario now are able to hold land other than for its own charitable purposes. But you need to make sure, this is not a sign to say go out and buy land everywhere and hold land if you want to. You need to justify why you're holding that land. There are often very good reasons why you may want to hold land. You may have been given a gift of land and you have to hold on to it or whatever, or you may have a parking lot, or you may just have plans down the road to expand and you can rent it out until you expand. You just need to justify why you're holding it. It needs to be part of your whole investment strategy and plan that you have. The other one is the repeal of the Charitable Gifts Act. The Charitable Gifts Act was passed in the 1940s, and basically it was a response, although it was denied by the government at the time, but to Joseph Atkinson leaving his interest in the Toronto Star to a charitable foundation. I believe it was a conservative government at the time, and the Star was more of a liberal-leaning newspaper. And I think the concern that tax dollars and this newspaper would be in the charitable sphere and not in the regular for-profit business was of concern. So the Charitable Gifts Act actually limited charities from holding more than 10% interest in a for-profit business. You could be gifted that interest, but you had to sell it within 7 years unless the court gave you extension for that time period. This was a major difference from other jurisdictions in Canada. Also caused some problems with CRA's for-profit activities, because CRA wanted to ensure that if you were doing for-profit business, it was outside of the charity. You had interest in a for-profit corporation, but you weren't doing business activities within the charity. They wanted, unless it was for furtherance of your charitable purposes. So now with the repeal of the Charitable Gifts Act, charities are able to hold for-profit interests in property. Now, because we can't just give complete gifts to everything, to everyone, we also at the same time did amend Section 8 of the Charities Accounting Act. So while charitable organizations can hold an interest in charitable in for-profit businesses, we do have authority, and the court does have authority to deal with those interests. So if there are problems with it and the charity is not getting the profit from that business they should be getting, there can be an application to court to have a determination. So there still can be some scrutiny of it, but the big difference is that there's not an outright prohibition, and it is only based, again, on when issues are raised. There's no requirement to file, no requirement for notice. Under the old Charitable Gifts Act, we had to approve profits each year of those organizations that you held until you conveyed it. So this is a huge step forward for charitable organizations in Ontario to really pull and reduce the regulatory burden that charitable organizations had in Ontario. So thank you very much for your attention, and I hope you all enjoyed the conference very much as I did. Thank you.